The sort of gross negligence in a very important financial transaction that calls into question her competence, or she's a liar, and her trustworthiness is in question as a financial regulator. So it's bad either way you cut it. If she screwed up on the documents twice, can she read? And even if she made them inadvertently, it's gross negligence. So either way, Trump wins. That is cause. Fraud is an excellent reason for removal, not merely a permissible one. And if Congress doesn't think she was fraudulent, well, they can impeach Trump. All these nonpartisan committees, all these independent people who are just so much better than us, like the rest of us are bogged down in politics. And so politics doesn't go into economics at all, doesn't go into the markets at all. Give me a break, Jerome. In the Supreme Court of the United States of America, President Trump now knocking on their door on a major issue. This involves, of course, the Federal Reserve, which is illegal and needs to go away. The question, of course, is who runs the Federal Reserve? What branch is it tucked under? Is it just this amorphous pseudo fourth branch of government that controls our entire economy and we have no say over it essentially because they've got 14-year terms and it's just all run by people who have no names that nobody knows, never come into Congress? We have no accountability to us at all. Is that a democracy? Is that a democratic republic? No, it isn't. It is a rigged system that is not accountable to us, and they've sold it to everybody under the name of economic stability, and they're going to handle inflation, and we're never going to have any bank runs because, of course, as you know, we've not had any of those since 1913. Okay, so now Lisa Cook, this is a big issue because it is begging the question, where does the Federal Reserve live? And we know where it lives, under the executive branch. We have one executive branch. The Federal Reserve Act of 1913 was an act. It's not an amendment. And so they can't create a third branch of government that is immune from executive oversight. And here's what they write. All right, Supreme Court, we're here. We've been appealing this thing for quite some time, coming out of Judge Gia Cobb's sorority sister over through the DC Circuit Court of Appeals, and now we're on your door. Remember, Gia Cobb said Lisa Cook has to be shoved back in there, whether you like it or not. Now, the application involves yet another improper judicial interference with the president's power to remove people. Now, this one involves the Federal Reserve Board of Governors, and it's not a discretionary removal. Remember that the statute says, and I think that the president honestly has more power than even for cause. Like, I think the president can just remove him at will. If Congress wants to separate that out, then they should make the Federal Reserve a fourth branch of government. Okay, come up with some other structure and have an amendment for that. So the Federal Reserve Act broadly authorizes the president to fire people for cause. It's not for cause except if the fraud is committed before or the problem happened before she came into power. It's for cause, period. Judge Gia Cobb is illiterate. Without further restricting permissible types of cause. There is no permissible types of cause delineated. So in August 2025, Trump determined that cause existed to fire Lisa Cook from the board. And as her removal notice observed before taking office, Cook had made contradictory representations in 2 mortgage agreements in a short time, saying that a property in Michigan and Georgia in Fannyland would simultaneously serve as her principal residence. Now, each mortgage agreement described in the representation was material to the lender. And we know the reality, lenders give lower interest rates for primary principal residences. Now, when her apparent misconduct came to light, the president determined that her, quote, deceitful and potentially criminal conduct in a financial matter renders her unfit to serve on the board. And at minimum, either demonstrates, 1, the sort of gross negligence in a very important financial transaction that calls into question her competence, or she's a liar, and her trustworthiness is in question as a financial regulator. So it's bad either way you cut it. If she screwed up on the documents twice, can she read? We know there's allegations of plagiarism against her from her time in academia. Somebody else doing that? To this day, Cook has never attempted to reconcile these representations at all or offered any substantive justification. There was that one word clerical in one of their filings. Well, it might have been clerical, but maybe not. But the district court nonetheless reinstated her. She issued the preliminary injunction and shoved Cook right back down everybody's throat. And the Court of Appeals didn't stay it. Now, Katsas, the dissent that we read earlier this week, explained those decisions flout the literal precedent of this court, the Supreme Court, from the removal process due to the equities. And so this injunction should be stayed. We should not have Lisa Cook back in the Federal Reserve at all. Now, this application, to my earlier point, doesn't contest the constitutionality of the for-cause removal provision. It says we're literally in compliance with the law. Now, to start, the government is likely to succeed on the merits because Cook lacks a Fifth Amendment property interest in her position, which is a disgusting even idea, right? That you have an ownership interest, a property interest in a Federal Reserve Board seat. Like, you own that. And if you deprive somebody of property without due process of law, that's a problem. But she doesn't have a property interest, so there is no deprivation happening. The lower court's primary theory is that the principal officers are akin to teachers or lower level civil civil servants. And so therefore they can claim an entitlement and a property interest to notice and hearing before removal. But this theory doesn't work at all, and it would wreak havoc on sensitive presidential decision-making. In fact, the Due Process Clause concerns only deprivations of life, liberty, and property. Cook wasn't deprived of any of those things. The lower courts treated her office as a Federal Reserve governor as a form of property based on this other 1985 case, which was a case involving the firing of a tenure-protected security guard. Okay, so this person was granted tenure, then was fired, and they removed it, saying that was a tenure-protected security guard, okay? A security guard, not a government employee. So he had a private contractual right to the tenure. He's not holding a federal government position as a security guard, not a principal officer of the United States, crazy people. That theory contravenes this other holding, which has been a long valued principle of America, that we don't have public offices that are public property. You're not granted a patent of nobility or a title that's passed down to your family, and that an officer has no vested interest in an officer to which he's appointed, even if you're removed from cause. Now, the lower court's due process theory would invite judicial micromanagement of the president's Article 2 powers, which is exactly what Judge Gouveia wants to do. Now, regardless, due process is a flexible concept, and so whatever process is due to principal officers was given here. The president notified Lisa of the charges against her and waited 5 days to respond before removing her. She provided no explanation at all. So having declined to bring any defense to Trump's attention or to dispute any material facts at all through her lawyers or anybody, Cook cannot complain about insufficient process. She got plenty of process and just sat there, not doing anything. So then Judge Gouveia, she said, well, alternatively, the president's reason for removing her, unexplained mortgage fraud, is not actual cause because she committed the fraud pre-appointment. Okay, so as long as you can just get in, like get through the doors, man, or rather get out of the doors, right? It's like a Black Friday scene. As long as Lisa Cook runs out the front door with the big screen TV, 2 of them under her arms, huffing it out of there, as long as she gets out, she's good. Nothing you can do. Sorry, she got it. Nothing you can do about that. She has to be your Federal Reserve governor. So that rationale is so flawed that the DC Circuit did not adopt it, and even Cook didn't press it. Okay, nobody said that. It's ridiculous. The Federal Reserve Act's broad for cause provision, that's all it says. It doesn't say for cause after appointment or for cause only for, criminal convictions or anything. It doesn't say anything. Whatever you want. For cause. Who decides the cause? The president. Well, we don't like that cause. Okay, well, you should be the president because you're not. But so long as the president identifies a cause, the determination of some cause relating to conduct, ability, fitness, or competence of the officer, the president has unreviewable discretion because they're the president. Judge Gouveia Cobb is now thinking she is. That came from Judge Katsas, which we read. The president's strong concerns about the appearance of mortgage fraud, John said, Lisa's not running out the door anywhere. She's not running anywhere. Says, based on facially contradictory representations made to obtain mortgages by someone whose job is literally set interest rates, it's the appearance of impropriety in addition to the actual impropriety. And the appearance of impropriety absolutely satisfies cause. Now, that is especially true here, where Cook has not disputed any material fact or offered any plausible justification for her conduct at all. Just sat there and didn't do anything. By reading in an atextual requirement that those representations had to occur while she was in office, Judge Gouveia disregarded Congress's literal choice. Okay, they could have put in here, you can only remove for cause like inefficiency, neglect of duty, or malfeasance in office, all right? That's a standard, which is a broader formulation that's been discussed in other cases, but Congress didn't write that into the statute. And so Judge Gouveia, her logic would create results that Congress never intended, and it would have prevented the removal of a governor if somebody committed a murder before taking office, or who bribed a senator to ensure confirmation, right? That's a great example. You can do whatever it takes, but as long as you're confirmed, you're good. Now, in addition, Judge Gouveia, she lacked authority to order the reinstatement. It's ridiculous. And a bunch of other cases have already come down, okay? She's just ignoring the Supreme Court because her sorority sister needs her to. So Trump versus Slaughter, Trump won, person's gone. Trump versus Boyle, Trump won, Boyle's gone. Trump versus Wilcox, same pattern. The remedy is not to force them back into the executive branch. If they want to go sue and make a claim for monetary damages, they can go do that. But the remedy is not you have to work with this person who the executive branch fired. And the Supreme Court confirmed that many times. So this conclusion is particularly clear in this case too. You can't shove Lisa down Trump's throat. The equities too also favor Trump and the government, writes D. John Sauer to the Supreme Court. The government faces irreparable harm for allowing this person to continue to function in the executive branch over the president's objection. And moreover, Trump has determined, the president, that because of her serious misconduct, the American people cannot have full confidence in her integrity, We can't trust that she's faithfully executing the laws. And so we require her immediate removal. That's cause. That the Federal Reserve Board plays a uniquely important role in the American economy, which is ridiculous. Put simply, the president may reasonably determine that interest rates paid by the American people at least should not be set by a governor who apparently lied about material facts so that she could get lower interest rates herself and refuses to explain the apparent misrepresentations completely. So this court, Supreme Court, should stay the lower level court's deeply flawed injunction and grant an immediate stay. And don't make us have Lisa Cook in this fake branch of government. Here's what they tell us, okay? More background on the disgusting Federal Reserve. In 1913, Congress enacted the Federal Reserve Act because they're just pathetic. And they're like, we can't handle this ourselves. So we have to create some other board to handle this for us so that we can just continue to be here and grift off the public without doing any actual contemplative work. 2 decades later, then Congress enacted the Banking Act, which reorganized the Federal Reserve and gave us the modern structure. So it's even like more recent than I was saying. The modern structure, less than 100 years old. See that? And it's unique and so important in our country. Have we not had any boomer busts since 1935? Today, the Federal Reserve System includes the Board of Governors, 12 regional Federal Reserve banks. The Board of Governors consists of 7 members appointed by the president with advice and consent of the Senate, and they stand in there for 14 years, okay? It's more than our senators, it's more than our House representatives by a lot, unless they're removed for cause. They said, well, this is for stability. We don't want this to move around a lot so that we can just have the same people ultimately running things. Now, Congress initially adopted this for cause provision in 1913, then repealed it, then restored it. The 7 members of the board, along with the 5 representatives of the bank, they make up the 12-member Federal Open Market Committee. And that's the body that conducts the nation's monetary policy. And how often do you see like cameras inside all of these little meetings, like committee meetings that you see in Congress? The committee sets federal funds rates, the target interest rates. They all lend money to each other. Nobody knows how it works. The board, the committee, then use various monetary policy tools, like adjusting the interest rates on deposits at the Federal Reserve banks. And they just make more money out of thin air constantly. I mean, they have like the quantitative easing and all these weird things. What's going on over there? No one really knows. Separately, the Board of Governors exercises broad regulatory authority as well. And now exercising that authority, the board has issued rules about matters like minimum capital requirements for banks. So we don't have any bank failures because we never have those. In 2022, Biden, who is brain dead, appointed Lisa Cook, an alleged plagiarist and alleged fraudster, to fill the remainder of that term that expired in 2024. Now in 2023, Biden, with the advice and consent of the Senate, reappointed Cook for 14 years, baby. You're stuck with them. And if they commit fraud, nothing you can do about it as long as they got into positions of power, says Judge Gouveia. On August 15th, the director of the Federal Housing Agency, William Pulte, sent a criminal referral to Pam Bondi about Lisa Cook. He said there are 2 mortgage agreements that were entered in within 2 weeks of each other, less than a year before joining the Federal Reserve Board, okay, because she knew she was going there and she needed to go buy some assets and offload some cash because she knows once she's going to be on the board, she can't do that stuff. So she does it with malicious, sneaky intent. In each agreement, she says that I would live there as my principal residence. She didn't. On August 20th, Pulte publicly released the referral letter, and instead of issuing a statement about why she did this or addressing anything, she just said the following: I have no intention of being bullied to step down from my position because of some questions raised in a tweet. Okay, well, you should have given it a little bit more attention to that. They weren't some questions raised in a tweet. It was a criminal referral from Bill Pulte over to the President of the United States. Okay, so you can call it a tweet and just brush it off like it's meaningless, but it isn't. 5 days later, after it was clear that there was no explanation coming, Trump removed her. In a letter to her, he said, you have a tremendous responsibility for setting interest rates at the Federal Reserve. And now you're apparently lying on your documents to get lower interest rates. So the American people don't appreciate that. We don't have confidence in your integrity or your trustworthiness. All of this notice and cause articulated. There is sufficient cause to remove you. So then Cook sued. She went and hired Abby Lowell. She sued Trump, the Federal Reserve, and the chairman of the board and said, shove me back in there. Then her sorority sister, Judge Gouveia, shoved her back in there indeed. Said she's going to win because this isn't good cause. Of course, we know that the president exercises the cause, not a judge. And the cause was dishonesty in her mortgage application. So then Gouveia said, actually, you can't say anything about it because she did it before and you didn't catch her. Now, the district court also said she was going to win because of due process claims and more, and saying she is going to have irreparable harm. And the harm is she can't be a good public servant. So the district court issued an injunction. A divided court of appeals denied the request for a stay. Judge Garcia joined. Judge Katsas dissented. We read the dissent here, and here's what we've got. To the Supreme Court. We're going to win this, you know. Her due process claim is a failure. The position that she held is not property. She wasn't deprived of any property under the due process clause at all. Now, even if it were property and it's not, she got notice and process before she was deprived of it. She had notice of the firing and an adequate opportunity 5 days to respond, and she didn't do it. And she raised no material factual disputes. There was no further process. She didn't deny it at all. So, okay, guess she did it. So the lower court's contrary reading of due process would grant the courts freewheeling authority to regulate the president. Obviously, that's not how this works. So, as we know, this is not property. Other courts have concluded that some tenure-protected government employees, the other case they referenced was a security guard, maybe he was a government employee, they may have a property interest in their jobs, but it says officers definitely do not. Okay, like if the government gives an employee some type of tenure, then you can say, okay, that maybe in that context, you can have some interest because you're essentially been guaranteed future income and tenure. But officers, absolutely not. No property rights to their offices because they hold very significant power. Officers exercise significant government power, and no individual has a property right to that power. Bunch of cases. 1980 case called Crenshaw. This was a claim about a tenure-protected naval officer. He said, I have a property right. The Navy was doing a reduction in force, and you lose. No, you don't. You don't have a property right to the sailor. Sorry. Contract does give private rights of property, but an appointment does not. Similarly, in another one, right? This is a contract, so it's like tenure in a contract. Different than you serving in the government. Similarly, Taylor versus Beckham, a 1900 case, this court, again, Supreme Court, rejected a claim that a state deprived a gubernatorial candidate of a property interest when they used inadequate procedures of an election. They said, no, public office is not property. Get out of here. Same in another case, and it's been reflected through our precedent for quite some time. And this has evolved over a lot of time. We get the point. This has been extended in other cases, and especially principal officers, they don't have property rights in their positions, and that analysis continues on for quite some time. Now, they're failing to distinguish the other cases. In other words, Judge Gouveia and the Court of Appeals, they never even addressed all those cases we just scrolled through to distinguish them, to say, actually, we're right, this case is wrong, here's why. Didn't even do that. Now, to the extent that they emphasized tenure protection, but the naval officer who was removed didn't, they distinguished between a couple things, but their analysis was wrong. Now, Cook, she received notice of the charges. So all of that explains the rules, and they all are applicable to Lisa. She got notice of the charges once Trump published the referral. The district court said this wasn't good enough notice because there was no explanation, but that's ridiculous. The document itself explained the evidence. So she also did have an opportunity to present her side according to other case law, and she didn't. She had an opportunity to explain why no misconduct occurred, and she spurned it. Now, even now, it's unclear. What would a hearing even accomplish? She's not responding to any of those things. And at no point did she identify any material factual dispute at all. Neither in her complaint nor in the multiple briefs. She just calls the accusations unsubstantiated, even though the mortgage agreements on their face contain contradictory representations. She hints, though never directly says, that they were error, hints at it with like that clerical word, from error rather than intentional wrongdoing, but she doesn't actually say that. But intentional or not, the misstatements is deeply concerning. Doesn't matter if she intended to do it or not, it's either intentional or it's negligent. So which one do you want? Either one's bad. Even if her acts reflect negligence, the president expressly determined that her lack of care is cause. It calls into question her competence as a financial regulator if she can't even fill out her own documents. Now, Gouveia, the judge at the lower court, said Trump didn't have cause to remove her because her conduct happened before you found out about it and appointed her anyways. And she relied primarily on that theory. Even though she did, the Court of Appeals didn't invoke it at all. And even Lisa Cook didn't bring that up because that's ridiculous, obviously. Now, the phrase for cause says any reason. It's not only for cause while in office. So what happened is the lower judge rewrote the law and imposed an in-office requirement where one does not exist because she is legally illiterate. Now, the determination of cause goes to the president. Gouveia can't substitute her discretion for the president's discretion because she's not the president. Congress has enacted different types of removal provisions. This one is broad. It says for cause. But the same conclusion follows here. Anytime we're talking about judicial review of a presidential action, can a judge substitute their decision for the president's? Obviously not. When Congress means to authorize judicial review, it says so very clearly. The statute here is not that. And so the canon of constitutional avoidance says she cannot review this here. The president's removal power, according to precedent, is conclusive and preclusive, meaning that exercising that powers may not be regulated by Congress or even reviewed by the courts. That's from another Trump case out out of the Supreme Court. It's in the Constitution, so you can't limit it. Otherwise, it's a violation of separation of powers. Now, this court, the Supreme Court, this is an open question, whether an exception to the removal power allows Congress to restrict the president's power to remove members of the Federal Reserve. Constitution says, and the Supreme Court has said, it is conclusive and preclusive, except the Federal Reserve for whatever stupid reason. So is there some exception? When the founders wrote that in there, did they mean it doesn't apply to certain people who are like special or historical or whatever? Court hasn't gone that far yet, but they're going to get there, and we're excited to see what they say. But no such historical exception could authorize this, since courts have found repeatedly those decisions are unreviewable. And so Judge Gouveia and her reasoning is flawed. So much so that the DC Circuit didn't even endorse it. They like, oh, it's an interesting decision. We're not going to talk about that. They cited a bunch of cases. And finally, Judge Gouveia worried that the government's argument would mean in practice, the president could remove members of the Federal Reserve at will. And that's not true, because they're not contesting the for-cause requirement. Now, that is incorrect. They write, if the president provides no reason at all, a court could review that, because the court is saying you're outside of alignment of the statute, and we think the statute's unconstitutional. But once the president identifies a cause, judicial review must cease. He identified the cause. You can't say it's a bad cause or a good cause, because now you're deciding on the cause. And the president has been delegated that power. Courts normally do not look behind a facially valid justification. If you did that, it would risk exposing the president's actions, everything he does. You could substitute your judgment. You could just say, actually, that's not good cause. That's improper cause. You don't get the right to say that. And if Congress is unhappy with the presidential decision, the proper check and balance on that is to impeach him or to conduct oversight over the presidential officers. The district court's concerns are particularly misplaced because the president has an independent obligation to faithfully execute the law. So the president, moreover, is the most democratic and politically accountable person in government, which is why the decision rests with him. And Trump had sufficient cause. For cause is very clear. If you have less confidence in them, then you can. Now, you also shouldn't be trying to step over the president like Judge Gouveia is doing, according to constitutional avoidance doctrine. But it's difficult to see how can we give her the benefit of the doubt? How could she have honestly represented that she was going to occupy two properties at the same time as a principal residence, Michigan and Georgia, within weeks of each other? She hasn't offered any explanation on this. And the word principal, it means first or rank of highest importance. It's her principal home. Does she not understand what it means? So if she made these contradictory representations knowingly, they could even be felonies, okay? Bank fraud, false statements. And even if she made them inadvertently, it's gross negligence. So either way, Trump wins. That is cause. Fraud is an excellent reason for removal, not merely a permissible one. And if Congress doesn't think she was fraudulent, well, they can impeach Trump. That's why we have the three branches, okay? Not kind of a pseudo fourth branch that just goes and sues in the Article 3 courts. The district court concluded for cause, she said it was only in office, Judge Gouveia. We know it's not. It doesn't say that. She tried to shove it in there because she can't read. The district court's theory defies common sense completely. The court reasoned that an officer's in-office behavior can reveal his inability, but an officer's behavior before taking office can do so as well. So her justification, if it happens after the fact, then it matters. It goes to that person's competency, and what they did 2 seconds before doesn't. Presidents routinely vet their nominees, but Trump found that it does impair her job. And if you do what Judge Gouveia says, we get absurd results. Imagine a governor who has amassed a great wealth and stellar reputation based on financial fraud, and you only discover that after he's in office. Can't do anything about it. What if Lisa would have bribed a senator to ensure confirmation? You can't remove her from that reason because she did it before she got the appointment. The district court sought to mitigate those consequences by stipulating the president could only remove somebody who has a serious crime, or if they're incarcerated or something. But again, she's just making it up and shoving it into the law. It doesn't exist. She should just read it again. The government also is likely to succeed on the independent ground that it exceeded her remedial authority. The traditional remedy is back pay, okay? You don't shove her back into her position. That has been repeatedly litigated. Even assuming she could take some reinstatement, the relief here is plainly unlawful. Bunch of other cases being cited here. One of the most well-established principles is that a court may not stop the removal of an executive officer. Look at all these cases. The court has explained this one right here in 1888, explained it here, 1898, another case, again in 1924, did it again in 1962. This principle has been established for a long time, and you've previously applied these same principles to other people, and because reinstatement is not a traditional remedy in equity, she doesn't get it here either. Now, these injunctions that shove these people back into the positions of power are a more severe threat to the executive branch than other provisions, like a writ of mandamus mandamus, where the court says you have to do this thing. We can't tell the executive branch they have to do something because we're not in charge of them, okay, for certain things. Now, a party may obtain a writ of mandamus only if it's clear and indisputable entitlement to relief, and she has none of that right here. She doesn't have that same evidentiary showing, and it threatens to cause a lot of confusion. And so we're going to win this. The issues in this case are definitely worth your review, Supreme Court. We've got questions. Can the president remove people who work under the executive branch? Can he supervise the executive branch at all? And as you recognize in a prior Supreme Court case not long ago, the government faces a serious risk of harm if you try to shove somebody back in there. Now, Gouveia doesn't care. She says the harm is to her sorority sister, and saying that the government doesn't have any harm if you just give her a little bit more time. But they say that's completely ridiculous. It's the president's discretion. Judges can't substitute their decision for that. And so they asked the Supreme Court to issue a stay. Stop Judge Gouveia from shoving Lisa Cook back into the Federal Reserve position and issue an order to the same. Respectfully submitted to the Supreme Court from D. John Sauer. So I think she's got a tough road ahead for her, rightfully so. And Jerome Powell, who apparently is allowing her to come back in, who maybe should be fired for cause too for doing that, is now getting asked questions about this over from the press. And here's how the question sounded.
As markets have questions about exactly President Trump's intentions are with the Fed, what would you point to as the things they should be watching to determine that the Fed is still making decisions based on, the economic outlook rather than political considerations?
Look, it's deeply in our culture to do our work based on the incoming data and never consider anything else. That's just everybody who's at the Fed really feels strongly about that way. So you'll know it by the way we talk about what we're doing, by the speeches that people give, by the decisions that we make. You'll know that we're just still going to do that. That's all we do. And we don't frame these questions at all or see them in terms of political outcomes. I think when you get to another part of Washington, everything is seen through the lens of does it help or hurt this political party, this politician? That's the framework. And I think people find it hard to believe that that is not at all the way we think about it.
Whatever, man. That's amazing, man. The Federal Reserve is like the only body in the world. It's like apolitical. It's incredible how that happens. All these nonpartisan committees, all these independent people who are just so much better than us. Like the rest of us are bogged down in politics. And so politics doesn't go into economics at all, doesn't go into the markets at all. Give me a break, Jerome. I hope that this is just a stepping stone on the way to just saying, yeah, Trump can run the executive branch. Unless they want to amend the Constitution and create a separate branch, this was created by an act, and all of these independent bodies exist under the executive branch. Hopefully the Supreme Court finds the same.